Calling page 3, case A 862-259, Shannon Ruth versus Nicholas Carter.
Morning, Your Honor. Dale Hayes on behalf of movant Nick Carter.
Good morning.
Good morning, Your Honor. John Kawai on behalf of AR, who's a plaintiff in the matter to be consolidated.
Good
or not.
morning.
Good morning.
Good morning, Your Honor. Mark Boscovich on behalf of Shannon Ruth.
Good morning.
Good morning, Your Honor. Jamie McAnally, also on behalf of Shannon Ruth.
Good morning.
Good morning, Your Honor. Alan Greenberg on behalf of Jerome Schuman and Melissa Schuman Henschel.
Good morning. Okay. So I've reviewed the motion to consolidate cases, plaintiff, cross-defendant AR's opposition, the reply. I'll tell you what I'm inclined to do, but welcome arguments. I am inclined to grant it under EDCR 2.50 and RCP 42A, the Nalder case, Marcuse case, common question of law and fact, some more details, but that's what I'm inclined to do. But welcome arguments begin with Mr. Hayes.
Well, Judge, in light of your inclination, I'll try to be brief here. As I argued in my moving papers, Judge, we think this is the poster child, these two cases for consolidation. The entire point of this rule is to promote judicial efficiency and to eliminate, multiplicity of litigation, and as well as the potential for conflicting rulings. That's exactly what we have here, Judge, is we have two identical counterclaims in two separate lawsuits that if they're not consolidated, they're just virtually going to proceed, parallel to one another. They're both virtually standing in the same discovery phase. Obviously, your case, Your Honor, this case is older. It's a year older. But because of anti-SLAPP proceedings, discovery was idled for a very long time. In fact, two of the litigants, discovery has never even began yet. And the other one, there's only been, I believe, 3 depositions, Judge, and 2 of those were taken since our motion's been filed. So both cases are basically at the inception as far as discovery goes. One of the primary arguments counsel makes in his moving papers is that, this is an isolated, separate, alleged sexual assault. But that's not at all what's going on here, Your Honor. It is these 3 alleged sexual assaults, that form the predicate for my client's entire counterclaim. That's the basis for the conspiracy, the grounds for the extortion, the fodder for the defamation, if you will, Your Honor. So I'll submit on that, and I'll just, in light of your inclination, but this case couldn't be more appropriate for consolidation, Your Honor. If it's not consolidated, we're virtually going to have 2 identical lawsuits proceeding in 2 different departments in the same district.
Thank you. Anyone in opposition?
Your Honor, this is John Kawai on behalf of AR. If I may be heard.
Sure.
Okay. Thank you, Your Honor. So, essentially, I actually do not dispute that consolidation for certain purposes does make sense. There is some overlap. The reason we didn't agree to consolidation off the bat for all purposes is that it does, there are really no common facts between the original claims made by the different plaintiffs. There may be some evidentiary issues in terms of, predisposition and all of that. But, if consolidation is granted for discovery purposes and we can reserve or later raise the issue of whether certain claims should be tried separately, then, we can live with that order, Your Honor.
Thank you. Anyone else in opposition? Okay. Any rebuttal?
Just briefly, Your Honor. Again, we've argued the facts all are common to one another. The only distinguishing issues here are the nature of the 3 different assaults. But again, it is those assaults that forms the basis of our conspiracy. So they have to be litigated in both cases, no matter what. So they're not, uncommon facts. And I appreciate Mr. Kawai's argument, Your Honor, if he wants to file a motion down the road to separate trial or bifurcate some issue, he's welcome to do that, as your honor knows, but this is our motion to consolidate, and we just ask that it be granted and the matters be consolidated. Again, all counsel was willing to stipulate to this aside from Mr. Kawhi's limited objection. So I think the writing's on the wall with this. Again, we believe it's the poster child for consolidation. I'll submit on that, your honor.
Thank you both very much. So I'm going to stick with my initial inclination, grant the motion to consolidate cases. To clarify, the granting is without prejudice, certainly as to any future type of motion practice. But it's granted, for all the reasons in the motion and reply. I'll touch on several of those in a little more detail even now. But Mr. Hayes, you'll prepare this order, make it detailed, put the reasons in there, submit it to Mr. Kawhi and everyone else who wants to for review and approval. But legal basis, under ADCR 2.50, NRCP 42A, the Nalder case, the Marcuse case, there are certainly readily apparent common questions of law and fact, both in the claims, which is, if I was only looking at, and put this in there, if the court was only looking at the claims, consolidation would be appropriate based on those common questions of law and fact, just in the claims themselves. Here, in addition to that, however, but in addition, we also have, the counterclaims, which provide an additional reason or bases for consolidation. Judicial efficiency, as is discussed in the actual law, would be supported by consolidation. The procedural posture of the cases also lends support to consolidation. And so again, that granting's without prejudice as to any future motion practice, but for now they're consolidated for all purposes.
Thank you, your honor.
Thank you all.
Thank you, Your Honor.
I'll prepare an order and submit it and circulate it.
Thank you.
Thank you.